No, I guess it was Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon. This is S-1-SC-39487, State versus Pennman. Can I have entries of appearance, please?
Michael J. Thomas, Attorney General's Office on behalf of the respondents in New Mexico.
Thank you. Mr. Kennedy, looks like you've divided your time 20 minutes and 10. All right, you can proceed.
May it please the court, counsel. On June 28th, 2018, three law enforcement officers with the City of Hobbs Police Department descended upon a family gathering of a family of African Americans in the city of Hobbs. Antoine Pennman, a member of that family, and his cousin were talking in the residential road. As described in the record, I think the road is a L-shaped residential street. Testimony was there was no traffic at the time. While they were talking in a residential street, the three law enforcement officers drove up to the area in two police cruisers. They stopped side by side in the street with emergency lights engaged and immediately detained Antoine Pennman and the other African American male. When detained, Officer Jaimes demanded identification of Antoine Pennman, and the objective as far as was to check for any outstanding warrants. Gathering on the sidewalk was the rest of the family, including Seamus Wright, who was a relative and uncle of the two young men. He started to voice his objection to what he saw as unlawful police activity, and saying such things as, "You have no right to be here, you have no right to demand identification." The police officers then focused their attention on Seamus Wright, and they unlawfully ordered him to remove his hands from his pockets, unlawfully told him to leave the area, and then unlawfully demanded that he identify himself. In retaliation for objecting to the detention of Antoine Pennman. When Seamus Wright stood on his constitutional grounds by insisting that the police officers are acting unlawfully and they had no responsibility to produce identification, his legs were swept and he was forcibly taken to the ground and arrested and threatened with a taser. These were not acts of police negligence. This was intentional police activity to dominate through intimidation the people that the police are meant to serve. The police acted intentionally in this case and used unlawful orders.
So can I?
Yes, sir. Yes, Justice.
Let's go to this term unlawful, and I'm not being facetious. As to the initial stop, what was, in your view, the unlawful? Why was that unlawful?
The initial stop of Mr. Pennman?
Yes, is it because of the reading of the statute?
Absolutely.
Okay.
Yeah.
Now, do you agree that for that stop, you have to have reasonable suspicion?
Yes.
You agree with that?
And if I may interject, and the record was that there was no other suspicion of any criminal activity other than pedestrian on the roadway.
Just this reading of the statute that we're involved in, right?
Yes, sir.
Okay. So here we are talking to five of us about how to read this statute, right? That's part of the issue. How we're going to read walking along, over, on. Why, even if the officer was mistaken as the law, if we concede that, why would it not still be reasonable?
Well, because it's not reasonable as a matter of law under the Fourth Amendment, and I think Article 2, Section 10, to mistakenly read the law.
We have a Court of Appeals opinion, I think, and correct me if I'm wrong, that it may be a mistake of law by the officer, if we agree it was a mistake of law, but it could still be reasonable suspicion to stop.
Well, I
Based
think,
on Heinen, the US Supreme Court case. Is that incorrect?
well, I think under federal law, there is clearly some leeway for a reasonable mistake of fact and a reasonable mistake of law.
Okay, have we accepted that federal law? Has the Court of Appeals accepted that federal law in State versus Dopsleff?
I'm not aware of that, Judge.
Okay, fair enough.
I-
I don't mean to quiz you on a particular
Justice.
case, but you can just answer the question directly, I guess. Do we or do we not accept that federal concept under the Fourth Amendment?
That's an excellent question, and I'd like the opportunity to actually brief that further if we could, because it wasn't addressed in our.
was not.
No,
The state did not address it.
exactly. So I think that's something that I would appreciate, a sort of careful attention to that issue, because as you know, I mean, we have an interstitial approach. There's been some criticism of that approach even, so it would be an issue. But further, Your Honor, is that the Court of Appeals decided that there was no reasonable suspicion to make this detention of Kenton Pennman. This was not challenged, and this is not, our position would be this is not before this court, whether there's a reasonable suspicion for the stop of Kenton Pennman. And so this appeal asks whether, when accepting the testimony of all the state's witnesses as true, and the state does not contend that there was any more evidence to present at trial, whether acting in the lawful discharge of duties, as the statute states, is an element of resisting arrest, assault on a police officer, and battery on a police officer can ever be or should be decided on a full and final motion under 5601B of the Rules of Criminal Procedure.
Under a full and final motion, if there's disputed issues of fact, can the court rule?
Absolutely not, Justice. Yes. I think that's clear from the case law. And I think that the Court of Appeals decided the Maras decision, which was actually very dissimilar. It was a police officer who was actually charged with I believe, not excessive use of force, but battery. And his defense was, I acted reasonably. And the district court said, well, I accept that as a matter of law. The Court of Appeals reversed on that issue, saying that the reasonableness question, and in that situation, the reasonableness question would be before a jury. And that case was decided before Full-and-Font, and the wealth of case law that supports the concept that a district court or Court of Appeals, when the facts are undisputed, may decide questions of law. In this case, the Court of Appeals opinion in this case is actually a very good example of that, because the Court of Appeals did decide the pedestrian on the roadway situation as a matter of law. The district court judge said, no, I think there's disputed issues of fact, but the Court of Appeals said, well, the facts are he was standing in the middle of the road. There's no testimony that he was walking anywhere, so we're going to accept that as true because that's the state's evidence. And as a matter of law, that does not violate the statute. Pennman also contends that the court erred by deciding for the first time on appeal that the new crimes exception applied to Pennman's detention. Pennman contends that the new crimes exception does not apply because the misconduct, including his own arrest, was flagrant, and the Court of Appeals called it negligent, and that his detention and the detention of Wright and his arrest for essentially not getting back far enough was one seamless activity by law enforcement that included many, many unlawful acts.
Assume for purposes of this discussion that your client seamlessly shot the cops when they went to go take him down. Same result?
I don't think so. And
Why not?
Because Well,
The initial stop was unreasonable,
right,
not supported by reasonable suspicion. They're going to arrest him, and he shoots him.
right. And now we're in a situation where he's charged with much more than battery on a police officer, but assuming a battery on a police officer at that point. At that point, I think you're into a situation where you go back to the common law where there is a defense allowed of self-defense, but the officer has to be acting using excessive force. So I think that's the area, that would be sort of going off into that area of the common law where that would apply at this point in time.
My question was really directed to the issue of the new crime
Absolutely.
that you say is not applied, that the Court of Appeal should not have raised that. Is the new crime exception, does that not apply there as well?
We contend it does not because, first of all, because the three elements are the time differential, whether there's any intervening acts, and the flagrancy of the police misconduct. Specifically, the Court of Appeal said, well, we don't have the record on the time. Well, there's a video of the arrest of Wright and the arrest of, to some extent, the arrest of Pennman, which contains some record of the time. But more importantly, again, we contend that this is not, there's no intervening act by Pennman that's going on because it's a continued detention. He was detained by Jaime's, and Jaime's, when he went to help with the arrest of Wright, basically said, hang on here.
Do you think the more appropriate remedy on the new crime exception would have been to remand for a determination as to whether the three factors apply? As opposed to the Court of Appeals taking a look at the facts and how they apply the three factors?
To be frank, Your Honor, it's difficult for me to be up here and arguing it factually, frankly, because it is such a fact-intensive issue. And Judge Sanchez did not have, well, Judge Sanchez found these behaviors to be lawful. So having now determined, the Court of Appeals determining that the arrest of Wright and the detention of Pennman were unlawful, I think that it would be appropriate for the district court to make the first finding. And frankly, district court judges sit in the communities, obviously, in which they hear cases and are familiar with what's going on in the community. And I think the district court judge at the first instance is better able to make a determination as to police misconduct and how flagrant it is, and judge the officers on the stand as far as their testimony and what their purposes were in that regard.
If we were talking about remanding to have a determination on the new crime exception, your client entered into a conditional plea, correct?
Yes.
So we would be bound by the record from the plea? Is that true?
Again, I'm not sure on that,
Okay.
Your Honor. Yeah,
Okay,
I'm not sure on that. And again,
fair enough.
Well, was there testimony presented on the Fullenfant motion? And the reasonable suspicion motion below?
yes,
Okay.
the full and final motion was heard, full evidentiary hearing. There is an issue, defense later filed an Ochoa motion, and that was denied by the district court judge. Defense made an offer of proof. The Court of Appeals said in its opinion, well, we should have alerted the district court to the offer of proof on that. So that's where the record stands on the Ochoa, on the allegations of misconduct. Obviously, an important part of our petition is that the defendant contends that the Court of Appeals misstated what should be the appropriate determination for lawful discharge of duties. And that's been an ongoing issue, I believe, since Doe 2 was decided and court and accepted State versus Frazier for its precedential value. State versus Frazier said, essentially, an officer is not acting in lawful discharge of his duties if he's violated the Constitution while he seizes a person. Now, the Doe court had a different factual situation where the officer who made the illegal arrest was not the alleged victim of the battery. And the alleged victim of the battery in Doe was a booking officer at a jail. And the Court of Appeals said, well, illegal arrest, you're out, you're done. And I think the Supreme Court said, no, that's not right, and used this test that's an agency test that's simply, are you acting in the discharge of your duties? And our position is a better framing of that would be essentially that once a person is arrested, whether lawfully or unlawfully, the public and the police have an interest in safely transporting and housing that person, whether it's a lawful or unlawful arrest. So in those situation, the booking officer, as far as I can tell, was acting lawfully, was acting in the course of what he's lawfully discharged to do, which is to search a person before they're housed in a county jail.
But the difference I see between Doe and between Frazier is in Doe, the officer clearly believed he was acting within the scope of his lawful duties. He thought he was acting correctly under the Constitution.
Yes.
In Frazier, the officer admitted, I had no right, there was nothing that allowed me to arrest this woman, and I knew that that was the fact. I just, there was this dispute, and I stopped her, and I ended up arresting her.
Absolutely.
I see those as two very different circumstances. How do we reconcile those two? What can we really get out of Frazier by the fact that it wasn't overruled when the court basically said, yes, if the officer admits that he was completely constitutionally out of bounds and knew he was, what can we really read into that?
Well, I agree with the court, with your honor. The problem with that is that now we're into a standard which is subjective intent rather than the objective behavior of the police officer. So if we're going to say that Frazier, in fact, anytime an officer says, well, I knew it was a civil matter and I knew I wasn't investigating a crime, well, is that a personal frolic of the officers at that point in time? Is that what we're going to say? I think a more appropriate standard is when in a resisting situation, when the officer who was engaged in the actual act of arrest is violating the Constitution, that's objectively unlawful.
Even if he absolutely believes he's acting within his authority, even if there's never been a case ever before that says this is a violation, and when it comes up on appeal, we say, yes, you violated the Fourth Amendment.
That goes back to Justice Thompson's question at the initiation of the argument, is because, yes, I believe that's the appropriate standard, because a number of reasons for that, because it gives the courts a objective determination rather than relying on subjective belief. And it actually encourages police officers and law enforcement departments to know the case law, to know.
Doesn't that also require defendants to know the case law? Yes, he violated my Fourth Amendment rights. I can haul off and smack him versus no, this is a close one. Maybe I can hit him, maybe I can't.
I think it's much less likely that the defendants will obviously read the case law. I think as the government and the state is engaged in the practice of detaining individuals for arrest. And so I think the responsibility is, and the encouragement is for the officers to know what the case law is and what the limits of the authority is. And again,
Because isn't the concern, I think from your client's perspective, isn't the concern that every officer will just say, I thought that was the law?
Exactly.
And it's going to whitewash every encounter by saying, well, I thought I was acting within the scope of the law.
Because
At the end of the inquiry, I was on duty and wearing a uniform.
I've lived in the qualified immunity world for a long time, Justice. And
You and me both.
yes, and in that world, it's come to and essentially, yeah, there's no case directly on point. How could I know that this would be unlawful? How could I know that this would be a violation of this person's rights? And again,
But even here, we don't have a legitimate, no, the statute didn't say that. I mean, I have a hard time with this officer saying the statute allowed him to do. So I'm not sure it's the same as a court later on saying it's out of bounds.
we agree. I agree, Judge. I think the statute was clear, as far as clear could be, and I think the record supports an arbitrary enforcement of that statute by this officer and by City of Hobbs Police Department.
So, going to the full and font motion, to me, the overarching question for us though is when do we take it out of the jury's hands to decide? And that's, I guess, my bigger, on the full and font specifically, that would be my bigger concern is
I think.
taking it out of their hands.
Yeah, I think we're in a situation where if as a defendant, if you're not willing to accept the police officers, in this situation, in many situations, and the original full and font was, the fence issue, and that's a pretty easy situation. But in a situation where if you're not willing to accept what the officer says is true, you don't have a full and font motion. So that you're accepting everything what the officer's testimony is as true, and I think you can get into.
Yeah, and I guess it's I think it's going to, in part to Justice Vargas's question as well, is just by ruling in favor as a matter of law that this was unlawful or not unlawful. Well, we wouldn't be saying it's not unlawful, but making the determination that it was unlawful and therefore it does not go to the jury. We've really got to decide what are questions of fact and what are questions of law. And I know sometimes one can be one and one can be the other, but to me, it would, generally speaking, be harder for me to want to take it away from the hands of the jury and say, oh, this is a question of law and it's not up for the jury to decide it. And that's kind of the overarching concern I have, much larger than this case, but still.
Right. And if I could answer that, if in this situation, we have two findings of unconstitutional acts. We clearly don't have a disputed fact about whether these police officers violated constitutional rights. They were. Courts have determined that they were. So in this situation, we don't have, while we have testimony, we don't have an in-depth sort of argument about exactly what happened when. And I think that's the case. And just to go back to Justice Vargas' question, I don't think, again, a person, again, as Judge Allered said in Phillips, a person who's arrested decides to smack a police officer. Well, he's still charged with battery. And Judge Allered said, and I think he's correct, is that the legislature increased the penalty to a fourth-degree felony with the proviso that you should be acting in the lawful discharge of your duties. If you're not, then we're back to the common law, and then we're back to self-defense and excessive force and things like that. Thank you.
Thank you, Mr. Kennedy. Mr. Thomas.
May it please the court. In this matter, Hobbs police were concluding a traffic stop, noticed persons in the roadway down the street, and believing in good faith that there was a violation of the pedestrians on the roadway statute, went to contact the persons and investigate further. I'm not going to get into the facts much. I think the Court of Appeals addressed them pretty well, but ultimately the petitioner received a conditional discharge after a no contest plea and obviously reserved limited legal issues. The Court of Appeals upheld his convictions except for the pedestrians on roadway statute, as to which the state has not sought further review.
How do we know the difference between good faith and bad faith in this context? There's a lot of emphasis put on, oh, it was good faith. It was good faith interpretation. How do we know that? What in the record, is there some kind of barometer in court that says, is there a finding by the court here of credibility or anything like that?
Thank you, Justice Bacon. What I would say, Your Honor, is I'll do my best to answer that, just kind of in the background of the fact that because it was a no contest plea, that largely what's in the record is a full and font hearing, which I did listen to the audio. Obviously, I've stepped into this case after my former colleague Morris I thought he did a good job on the briefs. But given the fact that it was a no contest plea, we're dealing sort of the limited record. I would just say that in looking at the record and looking at the Court of Appeals opinion, I say believing in good faith because the officer testified that he believed that person had likely violated pedestrians on a roadway station. Obviously, that was found later on to not be the case. The state's not contesting that.
But that I don't think we can view good faith versus bad faith through the lens of, of an appeal. It's in the moment. What is the good faith? And isn't every officer going to say, I had a good faith belief that the law said X, no matter what the facts are? So I don't understand how to assess good faith and bad faith in this context.
That's a good question, and I would say, Your Honor, that it would probably have, Justice, it would probably have to be an extreme case where the officer did admit, and I'm not saying this would be dispositive, but it would have to be a situation where the officer did admit something like, yeah, it was 3 a.m., we were bored, we were just gonna eeny, meeny, miny, mo stop the 10th pedestrian.
What officer's ever going to say that? I mean, that's the incredulity of all of this. No officer is gonna hang themselves out to dry in that fashion. And Frazier isn't gonna come up very often where the officer's like, yeah, you know, it's a civil, blah. And there it's civil and not an allegation of criminal. So I am concerned that every officer from here on out is gonna say, good faith belief, and then.
And I don't want to jump around too much, but to that point, I know there's a lot of intersecting issues, but I would say that certainly had it gone to a trial, I know the trial defense counsel may not have been Mr. Kennedy, but the trial defense counsel could certainly, had it gone to a trial, argue to the jury, hey, this was in bad faith, maybe a deposition that the officer reveals that he has a history of doing this out of boredom. I'm just saying that, and it kind of goes back to the lawful discharge of duty being a jury issue. That those are the kind of things certainly someone could argue to the jury that this was done in bad faith. He didn't have, he can't be viewed as acting in the lawful discharge of duties when it looks like he had no articulable basis to stop the person. But I guess the state is just saying, Your Honor, that there's really nothing here that would suggest bad faith. I mean, it wasn't like the officer admitted anything remotely. They seemed to be just wanting to look into this. In fact, the officer, there was testimony, I believe, through a deposition or somehow at the full and final hearing, I believe it was, that the officer said that typically if the person's cooperative and we talk to them and they don't have any warrants, we're just going to give them a warning and say, hey, be careful walking in the street. Of course, it escalated quickly, unfortunately.
So we're equating, at least a lot of the arguments have been equating lawful with constitutional, unlawful with unconstitutional, maybe a little bit too loosely. My question is this: can a police officer be in the lawful discharge of his duties and make an unconstitutional arrest? Make an arrest that is deemed to be unconstitutional.
I would say yes, because I know that the one view might be to say, well, we pay the cities, states, pay the police to only make lawful arrests and lawful stops and everything. But bottom line is we pay the police to deal with the public. And as a result, they're humans, they're not perfect. There's going to be situations where you arrest someone and then later on you realize, well, because maybe the interpretation of a statute or the facts weren't quite what we thought, it was dark out, whatever. Once they realize what was really happening, they may realize, okay, this person didn't do anything, we're going to let them go. Or maybe you arrest the person and later on it becomes clear it was mistaken identity. So I would say it's just part of the nature of policing. I would say the state's position is, yes, you can be in the lawful discharge of duties, even though you're going to make mistakes.
So those are mistakes of fact. I'll ask you the question I asked Mr. Kennedy, which is not in your brief. So quite frankly, I'm a little nervous about this question because I don't know why no one pointed this out. And you can tell me why, perhaps. You have State versus Dobbs left, 365 P 3rd 559. In Hine, the Supreme Court held that the officer's reasonable mistake of fact could support a finding of reasonable suspicion to conduct a lawful traffic stop under the Fourth Amendment, which is, to Senior Justice's point, as a matter of law, not as a matter of fact, if we concede that officer misread that statute upon along does not mean standing in the middle of. As a matter of law, have we accepted that concept from federal jurisprudence that the reasonable suspicion to stop is sufficient under a mistake of law or not?
To be honest, I'm not familiar with that case. So and like Mr. Kennedy could not answer it, I cannot answer it off the top of my head either.
Okay, fair enough.
Can I ask you the same question I asked Mr. Kennedy? I'm wondering why it's the Court of Appeals who determine whether the three factors were met for the new crime exception, as opposed to remanding to the district court to hold an evidentiary hearing if needed. I don't know what testimony was elicited at the hearing that already was held, but wouldn't the trial court be in a better position to address those three factors and make the appropriate findings and conclusions?
I can see why someone might think that it would have been better to remand it. I would just point out that I thought the Court of Appeals addressed this in the best way they could. I mean, they noted first that there was very little evidence about the exact time involved. And so the Court of Appeals even mentioned that because we lack the information about the time, we will weigh that in favor of suppression. So they gave the benefit of the doubt to Mr. Pennman, saying it's unclear, we're going to weigh that in his favor on the time lapse. On the second factor, intervening circumstances, I think that was properly weighed in favor of attenuation because, you know, the police go to stop him on pedestrians, everyone agrees, no reasonable suspicion, but the police are simply looking to investigate something. His remedy, if you freeze frame it at that point, his remedy is to go to court. I mean, ironically, had he accepted the citation and had this gone to court, by definition, the Court of Appeals, if that was the end of the case, the Court of Appeals would say pedestrians on the road, there's no reasonable suspicion, the case is over. But the reason why I think a Court of Appeals properly said yes, it's an intervening circumstance. He did this of his own free will. It's because at that point, you don't have the police just investigating someone, you have someone committing an affirmative crime against the officer, whether it's assault on an officer, battery on an officer. And I believe the Court of Appeals is correct to say yes, a new crime under the attenuation doctrine, that's enough. Now, in the third factor, the purpose and flagrancy of the police misconduct, it seems reasonable for the court to say we view that as negligent, not flagrant, because there really are no facts suggesting that whether it was purposeful and flagrant. I mean, that may be something the other side will disagree with me on, but I don't believe necessarily a remand was needed on that.
Mr. Thomas, I'm going to see if this captures what Justice Vargas was asking earlier of Mr. Kennedy. What record would the district court be bound by upon remand? Is it the record developed at the Falafont hearing, or is it all anew because of the no contest plea?
That's a good question, Your Honor. It's hard to say whether the court would have to hold a separate hearing on that, because otherwise all they would have mainly would be the full and font motion because of the fact he pled no contest, received a conditional discharge, and we don't have a full trial record. And I'll be glad to take more questions, otherwise I'll just continue on.
I wanted to ask you to talk a little bit about what to me seems to be some tension between State v. Doe and State v. Phillips. Phillips gets cited in quite a few cases that come before us on the same charges. And there seems to be some tension with Doe. And so I'd like you to hopefully tell me whether Phillips is good law, whether we need to overrule Phillips, whether Phillips can be read together with Doe, where it fits into this particular analysis.
Sure. Well, Your Honor, in Phillips, ultimately the Court of Appeals did rule that under that Detoxification Reform Act, they call it the DRA. They said the officer did have probable cause to put the person, to take him into protective custody, put him in the back seat of his patrol car. I know that they discussed in that case that the prior act had allowed them to take the person to a facility, and then I think in this case they said the person could be taken home. I can't remember all the details, but ultimately they did view that he had probable cause to take the person into protective custody. I'm not sure if the court necessarily needs to address Phillips that way. I know, of course, I'm aware that the Court of Appeals in this case said that discussion in Phillips was dicta because they found he had probable cause, and they felt that whole discussion going into I know Phillips, what I'm getting at, discusses the 1971 enactment of the battery on a peace officer statute and sort of the common law rule at the time, which is that if the officer was trying to unlawfully arrest someone, there was some sort of implied ability to defend oneself or use force.
So where I'm getting kind of hung up in Phillips is the way that Phillips analyzes the lawful discharge of duties phrase is to say that discharge of duties is taken, the phrase discharge of duties is taken from agency law, that it's basically like an employment type concept. But the lawful part of it that modifies discharge of duties is actually related to the legal authority of the officer, common law, statutory, or constitutional limitations of the officer's authority, and that's in paragraph 16. So this court has divided it up to say lawful means the constitutional violation or compliance with the Constitution, which, as I understand, is Mr. Kennedy's argument. And discharge of duties, the second part of that phrase, is the only part that is really related to the agency issue, which is the issue that Doe raises, that lawful discharge of duties arises out of agency law. So to me, there seems to be some tension between those two concepts. And I'm curious as to how you think we should resolve those. And it may be that you think that's just dicta and we should ignore it, but if you have other thoughts, I'd certainly like to hear them.
I understand the idea about saying lawful discharge. You have to look at common law, constitutional authority. The state's position is just that the fact that the officer later on was found to have been wrong about the application of pedestrians on the roadway here, I'm just not sure that takes this, says he was acting without any authority whatsoever. I'm not saying that would be dispositive, but I mean, if the officer was on his way home and it was after his shift was done, and maybe we get into some of those issues, but I don't think just the mere fact that an officer is wrong about a law applying means he was acting ultra vires in a sense. I mean, I think that's part of the same reasoning. I know the state has differed on that on qualified immunity, but I think that's the underlying reasoning behind qualified immunity just on a 10,000-foot federal level, is we understand officers sometimes make mistakes, and unless it was pretty clear, and I believe this was the first time pedestrians on the roadways had been interpreted. I know the court cited some cases from Washington, so I don't think it was clear. Now, maybe if it was a case where it was very clear, we might say, well, you really objectively should have known this wouldn't apply.
So yours, just so I'm clarifying, because I think that question was really good. Your position is it's on the mistake of law. It's because the officer made what you're calling a reasonable mistake of law. Is that?
Yes, I would say a good
okay.
mistake of law.
But do you think the analysis in Doe helps your position, and why or why not?
Yes, I do believe it does. Because Doe says, and I have it right here, I mean, Doe says, even if an arrest is effected without probable cause, a police officer is engaged in the performance of his duties and then of course they go on to talk about he's acting within the scope of what he's employed to do. And then of course the test is whether the agent is acting within that compass or is engaging in a personal frolic of his own. And then of course, they go on to talk about police officers must be free to carry out their duties without being subjected to interference and harm. And to try to touch on that, I believe Phillips is the case. I could be wrong. I don't want to be shuffling papers all day, but I believe Phillips is the case that said that if the officer is not acting the lawful discharge of duties, the person doesn't escape criminal liability. They may just be guilty of battery as opposed to battery on a peace officer. I believe that was Phillips that said that.
Yes.
And I do understand that someone can say, okay, if you're missing that element, then you go down to the sort of the lesser included offense of battery. But my concern is the state's concern, to be honest, is that the advocacy of this extremely limited attenuation doctrine and this unduly restrictive view of lawful discharge of duties, it will unfortunately, I fear, have a perverse incentive to cause people to want to gamble at the initial encounter. And I know one of the justices, I can't remember, touched on this earlier, but it's going to give people a perverse incentive to gamble at that initial encounter on the hope that a court will find that some mistake on the officer's part meant that he had no reasonable suspicion for that initial offense that caused him to contact someone. But these situations are fluid. He may find out the person's wanted for murder or has an arrest warrant. I don't think the law wants to give people an incentive to say, hey, I think that he didn't have suspicion on this issue, so I'm going to fight him because I think that I'm going to get the whole case thrown out. And
before you move on from attenuation, can I ask you another question about that? We've talked about whether we should remand for a determination on the attenuation doctrine to the district court. We've talked about We don't really know what happened in the time lapse. The Court of Appeals has addressed that. I'd like you to address the second prong, the presence of intervening circumstances. What circumstances do we consider in analyzing this particular case if we decided that this court was fine reviewing that?
On this, I believe that was addressed in that copy case 2018 NMSC.
I'm talking about this specific
Oh, this
case. What are the facts that we should be looking at to determine whether there were intervening circumstances?
Well, I don't want to overstate it, but I believe just the fact that it was just a new crime committed. I mean, the battery on an officer, the assault on an officer, those are things that, and I understand it was.
But then the battery is subsuming that factor in
Yeah.
the rules, so you're rendering the test meaningless.
So
If we just say there's a battery, so we don't have to
Yeah.
analyze.
I'm wondering,
what the intervening
do we step back from that? Where do we start? Do we start when they go to talk to Mr. Wright and he's putting the camera in the officer's face? Or do we start when the officer goes to arrest him? What facts do we get to consider in that number two?
And I would say, Justice, it's just not totally clear from copy right now, but I suppose the court could consider many things. Maybe the how much time had elapsed but before the person did something, whatever this new crime is.
But that's a separate prong.
Yeah.
no, that's a separate-
And we don't have the information from what I can
Right.
tell.
Yeah,
Right.
but it's an entirely separate prong, so again, what's the intervening circumstance from your perspective of the record that we have?
I guess that would be something that would have to be gleaned from Tapi. It's hard to answer that off the top of my head, except other than the fact that maybe it would just be enough that in this case, the officer having testified that it's typically, if a person didn't have any warrants, didn't have any reason to keep them, I would have let them go with a warning. Maybe the intervening circumstance is just the fact that Mr. Pennman chose affirmatively to fight with the officers and resist.
But the arrest is already happening, so that's after. So I still don't know what the intervening cause is, and I hope nobody says it's the use of a video, because that's a perfectly legal step. So I just don't, from this record, I don't know what it is.
Yeah, and other than, I noticed that Tapia does say, in many scenarios, courts conclude that even independent, nonviolent criminal acts following an unlawful detention may constitute intervening circumstances, reasoning that the conduct is neither natural nor predictable. I would just say that we don't want to just necessarily say that if you are arrested and you feel that it's unlawful, that you can basically fight with the officer all day, because
So, but if we're gonna write an opinion in favor of the state and affirming on this intervening issue, what would we write in that opinion? What facts would we write to support affirming for the state? And, cause I can't get that straight in my head either. Because we have to use the facts from this case somehow to support an affirmance, which is what you're asking us to do. What facts should we include in an opinion as to where that intervening cause is?
I would rely on Justice Zamora on the Court of Appeals said, of course, the state tends to agree with the Court of Appeals, but the Court of Appeals did write, and I'm sorry, it took me a little time to find this, but defendants, in paragraph 44, the Court of Appeals notes that defendant's physical altercation with Officer Martinez was not part of defendant's initial stop and interaction with Officer Jaimes, and was not a natural or predictable progression of his interaction with Officer Jaimes. Defendant engaged in combative behavior with Officer Martinez when Martinez attempted to place him under arrest. And I think they're trying to get it, and they say this here, the altercation did not progress from defendant's unlawful seizure by Jaimes, but rather was an unprompted act of his own free will. So I guess one way to answer it is we want to give people an incentive to just try to just fight it in court, take the citation and fight it in court, because by encouraging them perversely to fight with the officer on the hope that this won't be found to be attenuated, that there won't be found to be intervening circumstances, it's just going to unfortunately lead to more fights on the street, which I don't believe the law would support that. In fact, even in Doe, and I was about to read this earlier, and I'm sorry, I'm just going to try to get to this quick. Even State v. Doe in paragraph 10 said self-help measures undertaken by a potential defendant who objects to the legality of the search can lead to violence. and serious physical injury. I mean, this is sort of the flip side of what was sort of referred to earlier. And I know that, of course, people are gonna say, well, the officer's always gonna say, I had a good faith reason to stop this person. But and I'm not being specious, I'm being serious. What's to stop a defendant from saying, I was adamant, I was being arrested unlawfully, and I didn't want to wait to fight it in court. I was aware of this new case that came out months ago, this new case that talks about discharge of duties. I'm gonna fight this officer on the spot because I feel like there's a 50% chance I'm gonna win down the road. I don't think we want to encourage people to get into that application of law at the street level.
Okay. So let me, because I think, did you just jump from the new crime exception to the full and fun issue? Because I'm sorry, I just,
So,
yeah, I was getting, you did, okay. I'm just
well,
making-
I'm sorry, just.
No, no, no,
Just from the standpoint that I'm worried about the effects it's gonna have if people have an incentive to fight.
No, I understand. I just got confused because we were talking about the new
I
crime
apologize.
exception. That's okay. Just making sure because I want to make sure I give you credit for your argument. Thank you. Sorry.
I think Mr. Kennedy suggested, and I don't want to misrepresent the argument, that there is no intervening factor if in fact he remained detained the entire time. Can you address that argument?
Sure, I understand sort of the issues. Well, let's say the officer had let Mr. Pennman go and said, hey, I'm just gonna give you a warning. Granted, as it turns out, he was wrong, but if the officer had just said, hey, I'm gonna give you a warning, I think you are violating the statute, be careful walking the roadway, have a nice night with your friends, and they start to walk away. I don't think it's necessary that the officer let him go necessarily. It's sure, Mr. Pennman could have then, a minute later, as the officers were leaving, maybe thrown a rock in his patrol car or something. I don't believe that it cannot be a intervening circumstance under the second prong of attenuation merely because he's still detained. I don't believe so, because under that scenario, someone could say, well, they were still detained, they were fighting with the officer, they were still detained, so therefore, almost as a matter of law, they didn't stab the officer or do whatever they did, even though that's what happened in some hypothetical.
That logic overrules Doe. He was still detained when he was at the booking, when he hit the booking officer.
Oh, and I apologize if I misspoke. I guess I just.
No, I'm saying the logic that he was still under detention
Right.
would result in Doe being overruled.
Yes, Your Honor. Thank you, Justice.
I'm sorry, I didn't make that.
Oh, yeah, I'm sorry. And I understand what you're saying, which is, Doe was premised on the fact that all this happened when he was still detained, and yet Doe still said, yes, even if the initial arrest was unlawful, you can be still charged with these other crimes. So you're right, Your Honor, that to go down that direction would sort of eviscerate Doe. You're right, Your Honor. Thank you. Okay, well, at this point, Justices, unless there's more questions, I'll just make some quick concluding remarks and wrap it up. I guess I just wanted to cite a quick case from Maryland. The Court of Appeals case cites Travis and B. They cited it in a couple spots in the Court of Appeals opinion. And when I was looking at Travis and B, 2006 NMCA 146, I noticed Travis and B cites this Maryland case. Travis and B, 2006 NMCA 146 paragraph 9. They cite to a Maryland case, State v. Wiegman. And I thought that had a good quote. In that State v. Wiegman, 714A2nd, 841 at 849, Maryland, 1998, they say, quote, closed questions as to whether an officer possesses articulable suspicion must be resolved in the courtroom and not fought out on the streets. So I won't repeat what I said earlier. I just wanted to close with these thoughts, which is that petitioners' approach in advocating for what the state considers a narrow definition of lawful discharge of duties and a narrow attenuation doctrine. I mentioned the rest the state's concerned about. Sort of the summary of that is seen in the petitioner's reply brief at page 7, where it's asserted that petitioners, quote, approach to the arrest of right interfered, if at all, with an unlawful act of police. So end quote. This is page 7 of the reply brief. But the point is that no one knew that for sure at the time. And the state's not contesting that pedestrians on the roadways, there was no reasonable suspicion. That's probably why Morris, my former colleague, decided not to take cert on that. So nobody's disputing that. But the state believes that even if you have that lack of reasonable suspicion is established later on, after an appeal as occurred here, that does not negate the ability of this, for the state to arrest and prosecute defendant for new crimes committed. Petitioner's approach is a rabbit hole, like after the fact microanalysis of everything the police did. And I'm asking this rhetorically because I don't ask questions here, you all do. But why would we want to encourage people to hold some kind of a physical fight resistance trial on the street every time? Because most defendants who are arrested, most people who are arrested believe that they're being arrested unlawfully. This is a big misunderstanding.
Counsel, let me ask you another attenuation question before I forget it.
Sure.
You mentioned Chief Justice Bacon asked you a question about how one might prove that an officer was acting in bad faith, and you, I think, suggested that possibly a deposition of the officer, talking about his motives, if there was evidence that he had acted this way in the past, on several occasions, those might be ways that you could prove bad faith. I'm wondering if there had been evidence of that in this particular case, if defense counsel had come in. I know there was an Ochoa motion somewhere that got heard in part, but then there was additional information that didn't get considered. If all of that had come in, would attenuation be appropriate if they had come in and showed that the officer was acting in bad faith, maybe with what's being suggested here, an inappropriate racial motive? Can you attenuate a crime when the officer goes into the situation acting in bad faith because of a racial motive?
I guess it would be fact specific. I'd want to.
What about these facts? If there was evidence that the officer had acted in bad faith with an inappropriate racial motive?
I would say if the response affirmative crime against the officer was serious enough, I don't know if we'd want to go down that path of saying automatically, what if the person pulls out a gun and shoots the officer in the head? I'm not making light of that, but
No, I understand.
I believe that it would still be somewhat of a fact-specific issue, and I'm just not aware of facts in this case. I understand what the justice is asking. What if in this case there had been bad facts? The officer had a repeated a pattern of conduct of just rousting people.
Right. It would still depend on what the defendant did.
And the time lapse and all those things, sure. And I'll just leave it with this, and I don't want to take too much time. I'm almost out of time. But as the Court of Appeals noted in Travis and B 2006 NMCA 146, a person faced with unlawful police conduct has a remedy in a civil action, not in a physical attack. Part of my theme was just, Your Honor, that the state's concerned about the perverse incentives this may cause people to fight on the street. I mean, again, if Mr. Pennman had simply taken the citation and it had ended, by definition, the Court of Appeals would have said, no reasonable suspicion, you're free. That would have been the end of it. Thank you.
Thank you. Mr. Kennedy.
The scenario that the state presents of people fighting police officers on the street is implausible in this situation. And what we're really talking about is a step down of criminal responsibility. So if a person is arrested unlawfully in the street and pulls his hand away and resists, well, the person's not guilty of resisting a police officer. However, if the person strikes the police officer, well, the person could be culpable for battery, simple battery, rather than battery on a police officer. And if a person pulls a gun and kills a police officer, well, now you have you have murder, you have aggravated battery, and you have all those. You have you're back into the common law as far as your defenses are concerned. This is not a license for people to somehow all of a sudden fight with the police. And we're better with objective standards rather than subjective standards.
So can I ask you
Sure.
about an objective standard?
Justice.
So lawful discharge of duties. Seems to me if you focus on the word discharge, is the way in which the officer exercising their duties lawful? In other words, if they're, that's the question, it seems to me like that's what the statute is directed to. And that is that if the manner in which the officers performing their duties is lawful, even though the result of that discharge may somehow be deemed to be unlawful later on, or unconstitutional later on. Isn't that what the statute is really trying to protect? Is that the office, if the officer is exercising his or her duties in an unlawful way, or it's not an unlawful discharge, that is then not police officer battery if you're fighting. In other words, it's almost like self-defense against the police officer.
Absolutely. I mean, Justice, we're looking at after the fact determination. So we're allowing what we're arguing for is allowing the district court to say, well, even though you believe it was lawful, officer, that was unlawful, that was wrong. You had no right to tell Seamus Wright to identify himself. And that's unlawful, so the arrest.
No. He had a right to, he was asking him for his identity. But the way in which he was asking him for his identity was not unlawful. In other words, he wasn't pointing the gun at his head saying, give me your ID, something like that.
I absolutely disagree with the justice on that. A police officer on the street tells a citizen who, when he has a gun holstered and a taser holstered, tells a citizen to give me your identification. The citizen most likely is going to give the identification. Or, as Mr. Wright did, said no. And what's the result of that? If he says, yes, I'm going to give my identification, even though it's unconstitutional, yes, son, this is what happens with us. This is what happens in America. We don't have any rights. Or is he going to say, no, I'm going to stand up for my rights? Is
there any proportionality to it? Can he punch the officer? I don't disagree with your response, say, no, I'm not going to. But here, what we seem to be acknowledging, at least the state is arguing, is that the proportional response or disproportional response can be punching the officer.
Absolutely. And then.
Absolutely, they can't punch the officer?
No.
Okay.
That can absolutely happen, but he's going to get charged with a crime. It might not be a felony crime, but
Or may
it
not
may
be
be a
against the
felony, a
law.
lesser included crime of battery. So that's what we're talking about in this situation. And again, it's a legislative act. I think the legislature was very clear that it stepped up the criminal penalty for a felony, but required lawful discharge of duties.
Mr. Kennedy, let me ask you about, I asked quite a few questions about Phillips to Mr. Thomas. I want to ask you about Phillips as well. In Phillips, Judge Castillo-Foy wrote a dissent.
Yes.
And in her dissent, she disagrees with the way that Judge Alarid parsed out lawful and discharge of duties.
Yes.
And instead, she says that lawful discharge of his duties refers to the discharge of an officer's duties as authorized by law.
Yes.
That's what she believes that phrase says. How is that interpretation not more consistent with Doe than Judge Alarid's interpretation?
I frankly think it is more consistent with Doe.
Okay.
Justice, but I think Doe was wrong.
Okay,
In that area.
do we need to overrule Doe?
I think you need to modify, I think the court needs to modify Doe in that regard, because Doe got it right. But I think the better solution would have been that the booking officer was in the lawful discharge of duties. And Doe relied on a federal case, the United States versus Heckzer,
Yeah.
which interpreted federal statute, which doesn't say lawful discharge of duties, says discharge, essentially says, I have it written down. It's within the compass or in is basically, while engaged in the performance of his official duties.
Official
Federal
duties are
statute.
not coextensive with the power to arrest, is the Heckzer,
Right.
however you say it, takeaway.
So so I think Doe was relying on a different statute. I think in this country, as long as you're polite, the police are just going to cite you. But if you're not polite, I'm going to, confront you, and I'm going to tell you to get out of the scene in a public area where your nephew is being detained, and then I'm going to tell you to give me your ID because I want to run you for warrants. because I want to humiliate you and I want to show you that I have power and you don't. I don't think that's the kind of country we want, or state we want. I think the objective standards that we've talked about are the appropriate standards to apply in this situation. And as for his intervening circumstances, again, factually, Pennman began to use his cell phone, and the officer saw this, use his cell phone to attempt to videotape the arrest of his uncle, and was told to get back a number of times, got back. He was 2 to 3 feet, as the officer estimated, 2 to 3 feet, and then reappeared essentially when Seamus Wright was in a different place and started videotaping again from 4 to 5 feet, as the officer estimated. So there's no testimony that he was interfering with the actual arrest. It was simply, at that point, the officer decided to make the arrest and put hands on him at that point in time. And then the battery is alleged to have occurred with the shove. So as far as attenuation, we don't contend there was any intervening acts. So I'd like to close by just saying that we contend that the full and font motion was properly presented to this district court, and that the proper standard for the full and font motion should have been whether the officer was in the lawful discharge of the duties. Justice Thompson allows, or the court allows, we would like to do a supplemental brief on the issue of good faith, as far as, or reasonable mistake of fact and law, and whether the New Mexico Supreme Court should accept that. Thank you.
Thank you. Counsel, thank you very much for your argument today. The case is deemed submitted.